Time now for Night Court. Take you to Hawaii, where a group of short-term rental owners aren't quite feeling that aloha spirit. They say a newly passed ordinance could make their properties illegal after October. And they're suing the city of Honolulu for raising the minimum length of a stay in a short-term rental from 30 to 90 days. And while tourism is obviously a bedrock of the city's economy, many locals say the influx of tourists simply drives up their cost of living, including housing prices. So let's take it to our legal eagles to break it all down. Washington Times legal affairs reporter and attorney Alex Boyer and founding manager of Genco Legal, Brian Rotella. Brian, I want to share first the ordinance with you. It reads thusly: short-term rentals are disruptive to the character and fabric of our residential neighborhoods. They are inconsistent with the land uses that are intended for our residential zoned areas and increase the price of housing for Oahu's resident population by removing housing stock from the for sale and long-term rental markets. City Council finds that any economic benefit of opening our residential areas to tourism are far outweighed by the negative impacts to our neighborhoods and residents. I ask you first, Brian, because I'm curious, do they really believe this is legal, first of all? And second of all, if they move in this direction, won't that have unintended consequences?
Great questions, Kevin, but let me tell you, I do think that it is legal because they're trying to say there's an equal protection argument here, and I don't know that there's a constitutional right to have a 30-day Airbnb compared to a 90-day VRBO. But let me tell you, if I can, what I really do think, and I don't usually say this, but I'm on the government side here for being involved, is I think we need to make hotels great, and I think we need to make neighbors great. And why aren't hotels great? Well, anyone who's experienced it during the pandemic or post the pandemic, hotels aren't the same way anymore. We've scared people for the last 2 years that with your continental breakfast, you're going to get a side of COVID. And when you're at a hotel now, it's not the same stay anymore. You're lucky if you get housekeeping services the day you're there, if you get it at all during the stay at all, because there's a massive shortage of staffing. That is a major industry that is on life support, and this type of ordinance actually is helping hold up that industry. And really quickly, why does it help neighbors well? Well, what these 30-day rentals are, they're bought by big companies, LLCs, Kevin, and you end up having, if anyone's seen the Ozarks, Marty and Wendy Bird living next door to you with the cartel or whatever, instead of having the Bradys. And while I'm here in Tampa, not Tom Brady and Giselle, but I think we want more of the Brady Bunch living next door. We want neighbors that we know, not 30-day turnaround rentals. So to me, I think that there really is an interest in getting, one, the hotel industry back on its feet. Two, let's get back to knowing who our neighbors are instead of these big companies turning over 30-day rental after 30-day rental.
Yeah, I think there are a couple of things I would say about that. First of all, the pricing is really the problem, I think, for hotels. If you're gouging people or charging them extreme prices, people want to save a little money, especially if you're bringing family into an area. And I think the other thing is, you're right, you want to protect neighborhoods, but listen, it's liberty. If you own a property, you want to rent it out, why can't you do that? Alex, what's your take on it as we unpack that ordinance, which was lengthy? What do you say?
Yeah, I think the property owners have a couple good arguments. One, in their complaint, they cite a previous ordinance that they've been operating under for decades, I think since the 80s, where they say the minimum was set at 30 days and they should be grandfathered in. Essentially, that's something that's typical with zoning and permitting ordinances. Usually, if the city's going to say you can't have a driveway at an intersection within 25 feet, they're not going to go around to all the houses that do and say you have to tear that apart. And that's kind of what they're saying here. They're saying we want to use our same contracts that we've been using. The new ordinance can apply to new rental properties. And I do have a good constitutional argument. This is, as you mentioned, Kevin, private property. The government's coming in and limiting its use, taking part of it without just compensation. And the property owners have said in their complaint they've already lost business. They've had to cancel agreements because of this.
You know what? And it's interesting, too, because one of the complaints has been, we're talking about military personnel who come into town. They just need a short-term stay, doctors and nurses. It's a fascinating topic. I wish we had more time. We certainly appreciate you both spending a little bit of your Friday night with us, Alex and, of course, Brian. Thank you so much.
Thank you, Kevin. Take care, Alex.
Thank you.